Paragraph 15 is attempting to create causation. Open quote, police inaction emboldened defendants, continued conduct, increased fear, constitutional injury. Close quote. That causal chain has to survive both factual scrutiny and constitutional doctrine. Based on what you've outlined, there are major structural weaknesses. Number 1, pattern of refusal. If multiple calls were dispatched, case numbers assigned, officers reviewed complaints, voicemails left explaining findings, 2 separate agencies reached the same conclusion, no probable cause. That is not refusal. That is discretionary determination. A refusal to act claim collapses if records show repeated responses and documented investigative steps. Number 2, no probable cause equals no arrest authority. Police cannot lawfully arrest without probable cause. If investigations did not establish true threats, assault, menacing, stalking elements, trespass, then arrest would be unlawful. Courts do not impose liability for declining to make unconstitutional arrests. Number 3, recording in public video. Recording someone in public is generally protected activity under the First Amendment, absent harassment that meets statutory threshold, following that meets stalking statute, obstruction, true threats. Filming alone is not criminal conduct. If the alleged surveillance is public filming, that is a high bar to criminalize. Number 4, reciprocal online conduct. If he live-streamed defendants' videos, commented on them, insulted them, played their footage, publicly stated he would add them to lawsuits, criticized their content, engaged in adversarial commentary that strongly supports mutual hostility rather than unilateral victimization. Courts consider whether conduct is one-sided targeting or escalating reciprocal conflict. Mutual antagonism weakens stalking narratives. Number 5, enabled continued conduct. For municipal liability, he would need to show affirmative state action increasing danger or policy encouraging non-enforcement. A failure to arrest after investigation is not enabling. There must be something like direct communication encouraging defendants, disclosure of sensitive information, official protection of misconduct. Absent that, the causation argument is thin. Number 6, thumb drive with video links. This is important. If he provided links instead of specific time-stamped clips, expected officers to review hours of content, did not isolate alleged criminal statements. Officers are not required to conduct forensic media review absent specific articulable criminal content. Police are required to evaluate credible allegations, not perform unlimited media audits. If voicemails reflect that limitation, that supports reasonableness. Number 7, behavior inconsistent with claimed fear. If he continues live streaming, publicly mocks defendants, uses insults, cokehead, meth head, etc., plays their videos repeatedly, escalates litigation threats, remains publicly active that is not consistent with severe and incapacitating fear. It does not legally bar a claim, but it undermines credibility and damages. Number 8, removal of content after filing. If he previously showed defendants content, publicly discussed it, criticized it, then removed content after filing suit that can become spoliation or impeachment territory if relevant, it also affects narrative consistency. Number 9, the legal core problem with paragraph 15. To win against law enforcement, he must show 1, a constitutional duty existed, 2, officers breached that duty, 3, the breach caused harm, 4, the harm was foreseeable, 5, a municipal policy or deliberate indifference existed. From what you describe, officers investigated, officers returned calls, officers issued case numbers, officers determined no probable cause, 2 agencies independently reached same conclusion, conduct complained of may be protected speech, plaintiff engaged in reciprocal conduct. That is not deliberate indifference. That is discretionary law enforcement judgment. Number 10, real litigation outlook. Count 3, and these paragraphs likely hinge on whether any true threat exists, whether conduct meets statutory stalking threshold, whether there is evidence of bias or conspiracy, whether there is proof officers refuse to review clearly criminal material. If records are as you describe, this claim is vulnerable to 12b-6 dismissal, qualified immunity, summary judgment, because dissatisfaction with police conclusions is not a constitutional violation. If you want, I can outline the strongest possible counter-arguments he might attempt and where they would likely fail.